minchia ashofo na etefo na minchia mamunu makati. I think that there's been a bit of a fatigue in talking about this issue because Osimacha, and it was a foregone conclusion from the beginning. I mean, when there is two folds, purely law and purely politics. Okay, the politics side of it and the law aspect of it. Eban in Bremwa, the question that everybody will keep asking is that has law been followed? The law in Article 146 is clear. The grounds of which are able to make a Chief Justice. Either for stated misbehavior, either there ebia no ho dodo, another edwuma no ntumi ye incompetence. Inti so be the petitioner ba na president with the Council of State where well tum watch there some young pokonda be either you do much because that is a prima facie. If they are able to establish that, then they have to set up a committee. Inti say issue all the processes are then President Mahama Fiho ne her ladyship Justice Ato Torkonoo Fiho na fane there any president and any chief justice the processes are either offered on. Has it been followed? Yes, the president has followed its part in dealing with the issue, and that is the law aspect. I agree with the school of thought there, and I've said it even on this platform, that the same place you can get justice is the same place you can get injustice. Where you go for justice is the same place you can get injustice. So, Constitution and I am Brenum is like a knife. If you sharpen it and you give it to the wrong person, the person will use it for wrong things. If you give it to the right person will use it. It's not one blame there. A president can appoint somebody to the Electoral Commission. But if you give it to the wrong person, he will appoint Asedun Ketia as the chairperson of the Electoral Commission. And the president will not be wrong. Because he's a Ghanaian. What should the qualifications are? He meets the standards. And that is it. So we saw one not too long ago. And the person is still there. If my memory serves me right. Tuahini or what? Apiahini. He's still there. What's not do? Why part of panel discussions? But then the Council of State said the improper credentials warrant that yes, it can be, and he's a Ghanaian. So meet certain threshold. So why not? So the law has been used, but as to whether it has been used rightly or wrongly, it is up for our discussion. And that is the same thing with this. Because you see, when people even try to equalize with Charlotte or say, that becomes even more problematic. You understand? That even becomes more problematic. And the reason why it becomes more problematic in there, then it tells you there, if the removal of Charlotte Osei was okay, then how can you say this is wrong? If the removal of Charlotte Osei was not okay, then you can also justify this one. So let's treat each other separately. In relation to this, law process is being followed. Now let's go to the substantive things. The issues being raised is the threshold of stated misbehavior. You see, sometimes and I've raised this issue there, in our laws, indecent dressing is a crime. Indecent dressing. Otiambra. Oyembrem. So, na university na edwe yakoko yeduko parade. It is indecent dressing. We could have easily been arrested. The fact that one child in Chado Yimbrim, into that police who be decide to enforce that watch will be McCarthy's or demonstration against President Mahama on shut up. No police of fun. The McCarthy would demonstration in Konyabon, but you are indecently dressed or you are arrested. McCarthy won't even cut hey, why on one? That is how the law can be used as a knife. Okay, so that is why we need to be careful. So we sat down and knew that stated misbehavior is very difficult to state, to determine. What is stated misbehavior? Except people who would want to say that in the case of Charlotte Osei, in the judgment, they try to define stated misbehavior. But apart from that, per our laws, there is no CI that determines Article 146 how, in which manner it should be dealt with, especially in regards to stated misbehavior.
Until you're open.
Oh, you're open. And that is why they say the doors are open. So any other Chief Justice bar, you better be for stated misbehavior any day you are. So the whole discussion now has been muddied by the partisan nature of it. Who started the politics? Some say it's the Chief Justice. Certain utterances, certain posture, certain way or handle maybe looked more like she was also enjoying the political aspect of her job. So she got herself more into the politics of it. To the extent that even me, personally, I've had cause to complain that it's not by her direct influence, but I can't tell, probably yes. There, she was still presiding as Chief Justice when political parties went to court to put an injunction on the EC to do registration, limited registration exercise only at their district offices. Injunction, hearing date for the injunction was given after. Date now they say, no, yeah, after when the exercise itself will be done.
I remember, yeah.
So that itself is injustice. We went to court for justice, but we were served with injustice. So yes, and so many other things could be stated. I mean, people have talked about SAL. People have talked about how some people go to court within few hours and they're able to get judgment and all those things. So all these issues can be talked about, and the posture in which she had talked to even lawyers, senior lawyers, who are arguing on the angle of ABR. Another party that is not the party in government then. So all those things, Amama, it's become mixed feelings. But the relevant questions we should ask ourselves is that don't we think that we need to properly define stated misbehavior? Don't we think that there should be a threshold? Mom Benede Metakalim Obi Abom careless, me a Chief Justice, may roll it down, my ear yimpan. Are being taken off there, it is stated misbehavior. Would it be enough grounds for somebody who has worked for over 38 years, gone through the mill? Is it enough grounds? So we need a definition and we need a CI. For me, I think this time that the Constitutional Review Committee has done a job, I don't know what has been coined out in terms of Article 146, what the alternatives are. But I think that number one, we need to remove everything that will create political nature. Number one, the Council of State in our president Onyobaye discussed in terms of establishing prima facie. It is purely partisan. Nobody can tell me the Council of State is not partisan. The Council of State elections are in Kofuko Tueska. Queen, just to be able to get opposition to advise the president.
Kessben 92.9.
It's not political. Me go to Mampayinfo. Me go to Eska. I mean, what is this? And the danger of it in the we room, the mosque, everywhere, even House of Chief elections, people have become so partisan. So that in itself is problematic. We have suggested that there should be an independent committee that decides prima facie. The second option is that the choice of the people on the committee was done by the president, and it includes 2 judges and 3 others. 3 others are nominated by the president. So here then na president if him. So even though yes, president will follow law, but you can't say that he did not have any hand in it. And you see, if you are an NDC, be careful what you say today. Because the same justifications, and there's been videos of Honorable Afenyo Markin. You know, he went to court about Charlotte Osei.
Yeah.
Or in the last guy.
Yes.
You know, what they said, now they can't say the same thing. They can't stand by it. Things you say today, if you can't stand by it, be careful. And the same way MPP should be careful, because some American day or something else, we will play it back to you. That is why we now need to look at how do we address this going forward to ensure that we have a system that will work, whether it is NDC in power or MPP in power. I'm a member body behind there. In that some American, so 10 years, what but the principle of it underneath will be the same.
All right. Yeah, that's a citizen Ato Dadzie.